What happens if the person who's alleged to be the victim in a domestic violence case recants their statement later on during the case? My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado, and today I'm going to answer that question. So the way that a domestic violence case typically gets started is the police will receive a report that draws them out to a residence, and then they'll have contact with somebody, normally the reporting party, who will then make a statement that the person that they're involved in an intimate relationship with has committed some crime against them. And so if that report is made and the police officers believe that individual statement, then they will make an arrest of the suspected person, and they will then hand the case over to the district attorney's office that will then prosecute the suspected person, now a defendant, for a charge of domestic violence. Well, during the case, it is frequently common that the person who made the initial report and is listed as the alleged victim in the case will then come to the prosecutor to recant their earlier statement. And there are a number of reasons that somebody can make a recanted statement or decide to recant their statement. Frequently in these kind of cases, when an initial report of domestic violence is made, it is often made by somebody who is severely intoxicated, and many times once that person has had time to sober up, they will then realize that the report that they were making was not consistent with what happened. When you're severely intoxicated, you tend to misperceive somebody's actions, and so police don't wait for somebody to sober up before they charge somebody with domestic violence. They'll do everything, normally within an hour is how quickly those cases go from investigation to charge. So that's one reason that somebody will recant their statement. Oftentimes, somebody, when they're making a report of domestic violence, they're making a report when they're very, very, very angry at their intimate partner. And frequently I see cases where somebody is trying to get that person in trouble. And so making a report of domestic violence is a very good way to get somebody in trouble. But the consequences that even an allegation of domestic violence carry are extremely severe. And oftentimes that's not what the alleged victim intended when they made that report. They were just trying to get someone in trouble and didn't realize that that was going to involve them getting arrested and that there was going to be a protection order in place and everything. And so once the ball of the criminal justice system gets rolling, that's another reason that I see people come to the prosecutor to make an additional statement and try and recant their earlier statement. And then there are some cases where somebody is genuinely in a horrific domestic violence relationship with someone, and there is something called a cycle of violence, and there can be situations where somebody who is a victim of domestic violence goes through these stages of making a report about domestic violence and then recanting that statement later on. And part of my job as a criminal defense attorney is to find which situation this case really was. The prosecution in these kind of cases tends to have a bias towards believing that every time a alleged victim in a domestic violence case is recanting their statement, it's because they're in that third category of people that are just involved in these horrific domestic violence relationships. And I haven't seen that to be largely the case in my practice. Oftentimes, what I've seen is that people get into arguments with their spouse or significant other, and things just spiral out of control, and things are said which nobody meant and which oftentimes were untrue, but then somebody gets charged and we're off to the races on a very serious offense. And so what happens when somebody comes to the district attorney to recant their statement? Well, it depends on the district attorney. Some district attorneys will look at that statement, and if they believe it, they'll dismiss the case, or maybe dismiss some of the charges in the case, or offer a mitigated offer. Oftentimes, nothing will happen. Oftentimes, the district attorney will take that additional statement, or more accurately, have somebody that's employed by them take that additional statement. So normally, an investigator with the district attorney's office, and then they will inform the person that's alleged to be the victim in the case that it is only the state or the county in Colorado which has the authority to press charges against someone, or the authority to drop charges. The person who's the alleged victim does not have any authority under Colorado law to determine whether or not a case should be prosecuted or dismissed. And so that is typically the response from the district attorney, is that they have that additional statement, but they're going to proceed forward with the case regardless. Now, one thing that they do have to do is, if they obtain an additional statement from an alleged victim in the case, then they do have to provide that to the defense as part of discovery. The district attorney has an absolute obligation in every criminal case to provide the statements collected from all witnesses, including anyone who's alleged to be the victim in the case, and to disclose that to the defense as part of the discovery process. So if you're charged with a domestic violence case and the alleged victim in the case does recant their statement to the prosecution, then you will typically learn of that because it will come to your attorney, or to you if you don't have an attorney, as an additional statement. Now, how does that work at trial? So if a person recants their statement to the district attorney's office after charges have been filed, the district attorney may choose to still proceed forward with trying the case, and that's frequently the case. And so the way that it works is that when somebody is called as a witness or an alleged victim in a case to testify at trial, they'll have the opportunity to give their testimony to the jury, and that testimony may be consistent with the recanted statement that they gave to the district attorney's office. And so they may well come into trial and say, look, this charge was inaccurate or incorrect. Here's what the police got wrong. Here's why this statement was made in the first place. It could be a situation where they were too intoxicated or very angry. And they can provide that statement to the jury, and they'll do that under oath. What will then happen is that the district attorney will impeach their testimony at trial with their earlier statement. And so that is done by calling typically the police officer who took that person's initial statement, and then they will either have the officer testify about what somebody said when the police officer first contacted them about the case, or they will play that officer's body-worn camera footage to show to the jury that person's earlier statement. And the reason that they're allowed to do this is because the rules of evidence in Colorado allow the district attorney to impeach somebody's testimony at trial with any statement that is inconsistent with their testimony. And so then in these cases, the question becomes, which statement do you believe, right? And that's the ultimate determination that the jury has to make. Do you believe the statement that they made in court that day when they're testifying, or do you believe the statement that they made to police the evening that police responded to investigate this alleged domestic violence offense? Well, what to believe and who to believe is the question left up to a jury. It's a factual determination, so that is wholly within the jury's authority to decide. But attorneys in these kind of cases will make arguments about which account is more reliable and is more accurate. Now, naturally, the district attorney will argue that the first statement made is the one that should be believed. They're going to argue that it was made closer to when the alleged crime occurred. And they're going to argue that the person making the statement had a reason to change their statement before testifying because they may continue to be in a relationship with the defendant in the case, or may have made statements at trial that they didn't want this person to be prosecuted. And so the district attorney will then imply to the jury that the person testifying has lied, although in Colorado you're actually not allowed to say the word lie at trial, but that will be the implication. That the person is now making up a new statement to testify to the jury in order to help this person that they're in a relationship with. The defense is going to make a very different argument, and I find this argument is very powerful in domestic violence cases because the argument goes something like this. When somebody is called into court, they have to raise their hand, they have to swear an oath that they're going to testify truthfully. And their testimony is subject to severe penalties, even the penalty of the charge of perjury, if they provide false testimony. They are testifying to a jury of their peers, because that is the requirement for a jury. It's a constitutional requirement, is that every defendant is afforded a jury of his peers. And so the person testifying is testifying to members of their community about what happened. And then they are testifying after whatever emotions that were in play at the time that they made this original statement, or whatever substances that they were on when they made the original statement. Those things have expired. Enough time has elapsed that they are now sober and often calm when they're testifying to a jury. Well, it seems to be the case that somebody who is sober and testifying under oath and testifying to members of their own community is going to provide a statement that is more accurate and more reliable than somebody who is making a statement not under oath to a police officer in a situation where they're very, very angry and often intoxicated. At the end of the day, it's up to the jury to decide which one to believe. So that is what happens when an alleged victim in a case, in a domestic violence case specifically, recants their statement to the district attorney. It does not mean that the case will be dismissed, and many people are under the misapprehension that that's the situation. But it does mean that that additional statement will play into the evidence in a case in some way. So my name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado, and I want you to know the law and know your rights.